My name is Dona Kahn, and I'm an employment attorney with Anderson Kill, and I'll be speaking to you today about a case study in employment law. After the passage of the Civil Rights Act of 1964, a majority of claims involved allegations of race discrimination. Then in the late 80s, age discrimination was the focus. And in the 90s, sex discrimination and sexual orientation in the early 2000s. Thereafter, disability claims became the latest focus. The Americans with Disabilities Act not only requires that an employer not discriminate against an employee or applicant on the basis of age or the perception of age, and that's over 40, but that it provide accommodations for a disability, provided the accommodation requested allows the employee to fully perform the essential functions of the job and not be burdensome for the employer. It is also required that if the employer cannot provide the requested accommodation, it have a discussion with the employee of a possible alternate accommodation. I was retained by a company last year in which the employee was asking for an accommodation, part-time employment, which the employer did not believe it could grant. I reminded the company that it had to offer a possibility of an alternative accommodation and meet in person with the employee. The employer took my advice, and the case was settled for substantially less money than if they hadn't had that discussion. So make sure that not only do you deal with the request for accommodation, but you discuss an alternative with the employee. Again, my name is Dona Kahn, and you can reach me if you have any of these issues at Anderson Kill.